Hello. For this issue of the LP's V-Law review, I want to share with you some thoughts about the complexity of human rights protection systems and how it may harm the protection of human rights itself. Human rights protection systems today are extremely complex. This complexity is both internal, meaning specific to each system, and characteristic of the global architecture of international human rights protection. To put it simply, consider the most basic classification of these systems, which distinguishes between global systems and regional systems. The former have a universal vocation and are based on international organizations that themselves have a universal vocation, in the sense that they potentially admit any state among their members and are therefore able to extend their scope of protection to every individual in humanity. The most perfect example is the United Nations organization and its various bodies and mechanisms dedicated to guaranteeing human rights. The latter have a regional geographical scope, in the sense that they only admit states from a certain region of the globe as members or parties, so their scope of protection tends to be restricted to individuals under the jurisdiction of those states. Examples of this category are the Council of Europe system, led by the European Court of Human Rights, as well as the Inter-American system with the Inter-American Court of Human Rights, and, of course, also the African system. Within the UN system, there are several organizations with the task of guaranteeing or protecting human rights. Some are of an eminently political administrative nature, such as UNICEF, and are not equipped with mechanisms and powers to resolve disputes. They are essentially promotional. Others, the ones most relevant here, receive complaints from individuals against states, which truly embody disputes, and develop procedures to resolve them, which end with decisions or recommendations. These, although their nature and binding nature are increasingly debated, are not judicial because the bodies that issue them are not courts. But such decisions or recommendations put an end to an adversarial litigious procedure and have a parajudicial regulatory potential. Examples are the various committees that accompany the various UN conventions on the protection of human rights. All these committees receive individual complaints which give rise to litigation procedures between the complainants and the state against which the complaint is directed. These procedures are quite demanding in terms of requirements, assumptions, and procedural rules, namely active legitimacy, like the victim status, lis pendens, and the exhaustion of domestic remedies before a complaint is lodged. Within the United Nations, we also find the Human Rights Council, which receives complaints about quantitatively significant human rights violations. In addition to examining complaints, these committees, like the Human Rights Council, have various other mechanisms for protecting human rights, notably reports, investigative instruments, among others. Still, at the level of the United Nations, we must not forget the International Court of Justice. The ICJ is a real court, as distinct from other bodies such as committees. But it does not accept individual complaints. Article 34 of its statute does not allow this. However, as a court in which only states have legal standing, and which therefore does not accept complaints from individuals, the ICJ has heard many cases involving human rights issues. In some of them, which are relatively recent, the disputes between states have their origins in specific violations of the human rights of specific people. And although it cannot be said that the states were representing individuals in this case, there is clearly an approximation to this. It is undeniable that human rights protection systems are currently characterized by enormous, if not unsurmountable, complexity in a number of areas. The first aspect is material. There is practically no dimension of individuality that is not covered or assisted, at least in part, by some right protected by instruments of international law. From individual privacy to its family dimensions, from work to health, from education to political participation, from religion to culture, from justice to security. While not all the relevant aspects of these realities are legalized as individual subjective rights, there is a part of all of them that is, and this part tends to be relevant to the whole. Let's take the example of religion. Most of what a person's religious life is about is not juridicized, meaning it does not translate into or allow itself to be described by legal rights and duties. But the freedom of religion that many international instruments emphatically guarantee aims to ensure at least that it is not disturbed. Or perhaps the ultimate example, that of privacy. It is precisely because its diversity cannot be fully legalized that the corresponding protection starts from such broad areas of provision. In this way, we can speak of a double material complexity, that which is revealed in the multiplicity and scope of situations protected by human rights norms, and that which emerges from the apparent simplicity of the normative enunciations which, in an apparent paradox, allow that first multiplicity to be extended to the most diverse aspects of individuals' presence in the world. A second aspect is formal. Today, the number of sources of international law that are relevant to human rights, in other words, that reveal human rights, is overwhelming. There are thousands of norms of agreed international law, contained in treaties, conventions, and agreements of a less solemn nature, from which individual rights emerge. If we think of instruments of this nature that are entirely dedicated to human rights, such as the International Covenant on Civil and Political Rights or the International Covenant on Economic, Social, and Cultural Rights, the number is smaller but still in the hundreds. It is possible to pick out some of the most important ones, but this requires choosing criteria. The discussion about what actually makes up the so-called International Bill of Rights is a good example of this. Case law must be added to agreed international law, deliberately leaving aside the traditional discussions about its characterization as a mediate or immediate source. In fact, it is indisputable that the formation of modern international human rights law results to an enormous and decisive extent from the work of the case law of supranational courts, such as the European Court of Human Rights and the Inter-American Court of Human Rights. Without the jurisprudence of these courts, the effective content of each protected right would be subject to a level of permanent uncertainty and debate that would make it impossible to even dream of its effective protection under minimum conditions of equality. This can only include the so-called soft law produced by various specialized bodies, such as the general comments produced by the various United Nations committees, which have two primary functions: to enlighten states on their obligations in relation to the various rights, and to guide supranational courts in interpreting the rules that enshrine individual rights and which they are called upon to enforce or implement. Here, too, the traditional claim that these general comments are not immediately binding hides, or rather, does not explain their practical relevance. The third aspect is institutional. Several examples have already been given at the outset. Institutional complexity is umbilically related to the two previous trends. However, it is important to emphasize that this institutional complexity is not limited to the number of relevant international entities or bodies, which is impossible to catalog accurately, but is also revealed in the wide range of duties of each one and in the relationships established between them and states. In functional terms, they are both bodies of a judicial nature, such as the European Court of Human Rights, and of a political administrative nature, such as the aforementioned UNICEF or the Committee of Ministers of the Council of Europe. And even bodies of a hybrid nature, often characterized as quasi-judicial, such as the various United Nations Committee already mentioned, especially when they take decisions in litigation procedures between individuals and states whose characterization follows the same difficult paths. The fourth aspect is procedural. The rules that regulate complaints, procedures, and their development, for example, at the level of the European Court of Human Rights and the various UN committees, are today of enormous technical complexity and length. Complexity and length that are no different from those that characterize domestic administrative procedures and judicial processes. This complexity implies a huge technical specialization on the part of the operators, judges, experts, lawyers, which, as well as posing difficulties for them, also places them as gatekeepers to individual access to the protection system. But this complexity is not only found at the level of adversarial or litigious procedures. States' obligations to draw up reports for international bodies are themselves proceduralized in highly complex ways and oblige states to equip themselves with administrative structures capable of responding to these demands. Faced with these examples, and these are just a few illustrative examples, it is important to ask whether these complexities, resulting from an a priori virtuous purpose of protecting human rights, do not counter-effect, all things considered, to that same protection, as a consequence of the difficulties of access that they introduce as a result of bureaucratic knowledge and even economic aspects. Each of these aspects presents specific difficulties that must be analyzed in isolation. However, the following reflections will not focus on the latter, but rather on some general issues common to all of them. Until the middle of the 20th century, it was impossible to speak of a real autonomization of human rights, either as a general category in international law or as a subjective right held by individuals. It was even less appropriate to talk about the existence or even the idea of a human rights protection system. It didn't necessarily have to be this way. The historical experience of Roman law, based on actiones and not on what we today consider substantive, subjective legal situations, to which procedural rights are only logically associated at a later stage, and the need to find a common legal language between various legal systems, could have led international law in another direction. In truth, however, it was only with the approval of the Universal Declaration of Human Rights in 1948 at the United Nations General Assembly that a time began for a new general legal awareness that would come to demand the notion of a system of protection for human rights. Although we can debate the true meaning of the Universal Declaration, as well as that of the time that preceded it in terms of the idea of human rights, this was a key moment in the autonomization of international human rights law. As I have written elsewhere, international human rights law differs from public international law in subjective, objective, principiological, and formal terms. These distinctive elements, consequently, imply a different type of legal relationship from that which public international law classically disciplines. In subjective terms, the distance between international human rights law and public international law is determined by the primacy or centrality of the person and no longer of the state. Here, the individual is not a lesser subject in relation to others who can be considered the primary subjects of public international law, notably the state and international organizations. This primacy of the person is itself normative, producing consequences at the level of subjects of rights or other active situations and recipients of duties. For Alexei, this justifies the universality of human rights. Regardless of this justification, which is also linked to the distinction between human rights and fundamental rights, The explanation for ownership lies in the fact that human rights are rights that all human beings have, as individuals, regardless of their title to them. As for the recipients, a distinction must be made. Since they are rights erga omnes, or of everyone vis-à-vis everyone, the addressee is not only the state, but also other individuals or groups. But then a further distinction is necessary between absolute rights, which apply to everyone, whether the state or other individuals, like the right to life, and relative rights, which only make sense in relation to a certain category of recipients, like the right to vote vis-à-vis the state. In objective terms, subject matter and guarantee, that is, international human rights law is autonomous from public international law due to the specificity of the active legal situations, meaning rights, the passive legal situations, meaning the correlative duties or obligations, and the type of protection, guarantees. This specificity is surprising in two essential respects. Firstly, it is a specificity eminently linked to ownership. While the active legal situations in the field of public international law are functional, because they are held by legal persons who are themselves functional or instrumental, the state and international organizations, human rights have as their immediate justification the individual himself, protecting him as a person or in dimensions of his personhood that have historically become autonomous due to needs of various kinds. Secondly, it is an original specificity in that human rights are spheres of protection against the state itself, recognized by positive law and not prima facie of contractual origin, like most active situations in public international law. On the other hand, also with regards to the obligations or duties arising from human rights, the international human rights law is autonomous from public international law, given that states, by ratifying treaties or conventions on human rights, assume these duties, not towards other states, but towards people. This is why the reference literature often uses the expression special character to characterize these obligations. There are various reflexes of this speciality, but it shows a distinct orientation of the international human rights law in relation to public international law, namely by degrading the importance of the will of states, which is a pillar of public international law, and relativizing the notion of their sovereignty in this context. This implies a certain tension between matter and form, between human rights in material terms and their submission to treaty law, because when states sign up to international human rights instruments, they do so voluntarily, leaving aside, of course, non-voluntary sources. But the whole subsequent regime relativizes their will, since what is established is a guarantee against the state itself prima facie. This is why it can be considered that, compared to public international law, international human rights law has a dimension that is both radical and revolutionary, as Frédéric Maret says, supported by the quasi-constitutional teleology of voluntary sources. These obligations, assumed by states in the fields of international human rights law, are therefore sometimes seen as promises to the international community and to the individuals themselves, or as declarative rather than constitutive. As soon as rights are recognized, the hetero-binding nature of the corresponding obligations is recognized, with erga omnes effectiveness. The first reference to the special character of human rights treaties seems to be found in an advisory opinion requested by the International Court of Justice from the International Court of Justice by the UN General Assembly regarding reservations to the Convention on the Prevention and Punishment of the Crime of Genocide in 1951, in which the ICJ distinguished between so-called normal treaties and treaties on human rights or humanitarian issues. In the case of the latter, states could have no interests of their own, but would only share an interest common to all, consisting precisely of the objectives of the Convention, which constitute its raison d'être. States' obligations could therefore not be seen in the traditional logic of mutual advantages and disadvantages, nor of a contractual balance between rights and duties. The European Commission of Human Rights has adopted a similar view, expressed in the case of Austria against Italy, the Funders case of 1961. Italy, describing the obligations assumed by the states parties to the European Convention of Human Rights as objective, meaning that they do not counterbalance the rights of the other states parties, but rather the rights of individuals. The beneficiaries of the obligations assumed by the states parties are not themselves parties to the Convention itself, which thus moves away from signaling bilateralism and towards a pactum, recognizing rights and assuming obligations in favor of third parties. These aspects are manifested in the principle of guarantee, which is a good reflection of how the international human rights law is part of a movement towards the internationalization of the individual, based on the affirmation of human dignity, calling into question one of the main dogmas on which international law is based, namely, the character of the law of cooperation between sovereign states, which knows no legislator, no judge, and no sanction outside the framework of state consent, as wrote. The complexity of the human rights protection system is not disconnected, as we can see, from the complexification of its own theoretical framework. It doesn't seem particularly useful at this point, at least, to discuss which complexification precedes which. What seems more relevant is to note, from the outset, that the complexification of human rights protection systems is asymmetrical in terms of the consequences for their main beneficiaries, persons. In fact, there are natural asymmetries between the regional systems that stem from the different institutions and international instruments. Since the states parties, the founding conventions, and the institutions that make up the two are different, the Council of Europe system would never have the same line of development as the Inter-American system. And this has consequences for the results in terms of effectiveness of protection. As far as the global system is concerned, general developments and complexities are translated in different ways in the different states parties, and therefore in the effectiveness of the protection of people's rights. It is clear that results of the actions of the various elements of the UN system are produced differently in Norway and Nigeria, for instance, which is linked to the degree of development of these countries, but above all to institutional aspects. In any case, this is because of a decisive aspect that justifies the progressive complexifications of these systems, their evolution towards a form of control of public powers, and not just, and in some cases not mainly, towards a more effective guarantee of individual rights. I have already tried to explain this with regard to the European Court of Human Rights judgments, in the sense that they have progressively come closer to the judgments of the domestic courts that are responsible for judging the actions of public authorities. This explanation is, however, open to generalization. In fact, this is particularly visible in the global UN system. The set of reporting mechanisms available to various organizations, or the mechanisms for examining interstate complaints, meaning everything that doesn't consist of examining individual complaints that involve examining specific legal situations, is a kind of protection of states' parties that isn't intended to guarantee a certain right for a certain individual, but rather to produce structural or systemic results with regard to a certain right in general terms. For example, freedom of expression for journalists in a certain state, or a set of rights in general terms. For example, prison conditions in a certain state. This complexification, while virtuous on several levels, has consequences that need to be borne in mind. In particular, without prejudice to the results that can be achieved by identifying structural human rights problems, this can make states less willing to accept decisions on specific cases on the grounds that they are politically, not legally, motivated. There have been several cases of principled resistance to the spontaneous execution of judgments by superstate courts on the part of the states condemned by them, with arguments relating to the political nature of these decisions, which, from the perspective of these states, exceed the limits of the jurisdiction of the court in question. At first glance, there may seem to be no connection between such episodes and the complexification of the systems in which they occur. However, insofar as complexification translates into a thickening of tutelary type mechanisms over states, it is inevitable that they will establish such a relationship, albeit implicitly, and attribute it to a convergence in attempts at a supra-state constitutionalism to which they react. It is natural for states to think this, because that is precisely what it is all about, and the specialization of international human rights law vis-à-vis public international law provides part of the explanation for this movement. There is no way back from this complexification except through the destruction of international organizations and conventions. Although in recent years we have seen an increase in proposals for the later trend, it does not seem that this will be the path of international reality in the long term. It is therefore important to find a rational and reasonable legitimization on a legal political level for the aforementioned expansion of tutelary control over states in terms of compliance with obligations and standards arising from international instruments regulating human rights, while at the same time safeguarding the position of supranational courts from contamination in terms of the authority and enforcement of their human rights judgments. The complexity of human rights protection systems is also relevant on another level, as indicated above: equality. This complexity tends to be less relevant, meaning to have fewer negative consequences when it comes to guaranteeing the human rights of people who are in, but not necessarily citizens of, developed states, and who are firmly governed by the principles of the democratic rule of law. In these states, knowledge of possibilities for legal redress tends to be more widespread, professional support for those who want to assert their rights more extensive, and the costs inherent in such initiatives more bearable. This subject is far too complex to go into here. However, it is important to bear in mind that the complexity we are dealing with here is likely to increase universal inequality in access to the good, which is justice, in the supranational guarantee of human rights. This inequality, in turn, generates a paradox. Universal human rights, which are the most essential to the human condition, see their guarantee more variable than that of fundamental, meaning constitutionally based, rights. Although this can be explained by a number of factors, first and foremost, fundamental rights operate in the context of a certain political community and an organized political power with a constitutionally well-defined central core. which today are being reclaimed in response to a perhaps unjustified hope in the potential of human rights, this paradox is still there, even though the nature of human rights and fundamental rights is different. And there is a risk in this paradox, that of a progressive abandonment of human rights as a legal figure, as a legal situation, in a kind of pendulum movement that, after some kind of hyper-valorization, is now traveling to the opposite point.